Hello and welcome to this webinar on the Indian Child Welfare Act. This is ICWA 201, so slightly more advanced and focusing specifically on active efforts and qualified expert witnesses. My name is Delia Parr. I'm the Directing Attorney of California Indian Legal Services Eureka office and very excited to be able to provide this information to you today. Active efforts. Active efforts are services designed to prevent the breakup of an Indian family. They are not specifically defined within the Indian Child Welfare Act. Instead, they are required to be made on a case-by-case basis. And because of this, there is a lot of misunderstanding around what they are, when they're required, and how to really ensure that active efforts are being provided in cases where the Indian Child Welfare Act applies. So the first thing is that active efforts must consider a tribe's social and cultural standards, and that they are required in both foster care placements and any kind of case where a parent could have their parental rights terminated. So that would include not only foster care placements, but even cases like voluntary relinquishments, where a parent is giving up a child for adoption voluntarily. In practice, active efforts are included as a part of case planning, and courts should make active efforts findings in addition to reasonable efforts findings every time the statute requires reasonable efforts findings. Active efforts are required to be made to prevent the breakup of the Indian family, so that responsibility is essentially triggered at the very moment that a state court or county agency is aware that a family that they are working with would fall within the definition of the Indian Child Welfare Act and would carry through the entirety of the case. So active efforts are defined within the Welfare and Institutions Code at 25 U.S.C. 1912d, and what that section says is any party seeking to effectuate a foster care placement of or termination of parental rights to an Indian child under state law shall satisfy the court that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, and that these efforts have proved unsuccessful. So that's the actual language that's contained within the law, and you'll see what I was trying to explain on the last slide, which is that we don't get a tremendous amount of guidance through the law itself on what active efforts are. We are provided with some guidance on what kinds of cases active efforts requirements apply to, and we are certainly provided with some guidance that they're intended to prevent the breakup of a family. But specifically with regard to what constitutes active efforts, that again is a case-by-case analysis that we'll get into more shortly. Here we go. So what are the purposes of active efforts? Well, we know from the definition that we just read that one purpose is to prevent the breakup of an Indian family, but it's more than that. It's also to locate family and tribal members who can provide continuity for the child, and to recognize the tribe's interest and stake in its children, and lastly here to access benefits available through the tribe. That there are a whole variety of people and services that are available to Indian children through their tribal community, and active efforts are intended to utilize the available resources of that tribal community to try to ensure that the breakup of the family does not happen unless it's absolutely inevitable, and if it's inevitable, then active effort services are provided with regard to reunification of that family. So at California Welfare and Institutions Code 361.7, we get the following language, that the agency must use the available resources of extended family members, the tribe, tribal and other Indian social services agencies, and individual Indian caregivers. So this is the state law code section that has to do specifically with active efforts as they're applied here in California. And what you see encompassed in the California law is, again, this idea that Indian children are members of or citizens of their tribe, and as such they are entitled to maintain a connection with their tribal community, the tribe itself, and to be able to utilize all of the resources available through that community and the larger network there to be able to benefit that family as a whole, to again try to prevent the breakup of that family, and if that's not successful, to try to then reunify the family. There at the bottom of the slide you'll see two California rules of court mentioned, 5.482 subsection C and 5.484 subsection C2, which have to do with an agency's responsibility to take steps to secure a child's tribal membership where possible. These rules of court are the subject of a current California Supreme Court case. Oral argument was heard in early May, and we are anticipating a decision at some point. So certainly stay tuned for whether or not those rules of court continue to remain in effect. There is a webinar specifically on that case in Re Abigail A on the CILS website if you want to learn more about that. But for our purposes here, you just need to understand that there are rules of court that do currently say that there's an active efforts obligation on the part of agency to take steps to secure a child's tribal membership where possible. And in a very limited fashion, the challenge that has been made to these rules of court is that the phrase active efforts is used, which would then indicate that the Indian Child Welfare Act applies to that case. But in fact, the Indian Child Welfare Act, under a very strict reading of the law, would only apply to the case if either the Indian child was already a member of the tribe, or if the Indian child was eligible for membership in the tribe and a biological parent was actually a member of a tribe. So if you're in a situation where that's not the case, so the argument goes, then active efforts wouldn't be required because you haven't met the threshold determination of ICWA's application. So hopefully I haven't confused you too much there. If you want to know more about that, definitely go check out the other webinar on Re Abigail A available on the CILS website. So this slide contains the two arguments that are made most often, and they're usually made together in California cases. So the bottom one we've actually talked about in a previous slide. The top one is that as a part of active efforts, the party shall take into account the prevailing social and cultural conditions and the way of life of the Indian child's tribe. So all of this comes back to ensuring that services that are provided to Indian parents are consistent with tribal, social, and cultural norms, that they are not tainted with inherent bias, and that again they're really utilizing the larger network that is available to tribal families, which would include, of course, the tribe, Indian social services agencies, extended family, etc. So in February of 2015, the Bureau of Indian Affairs released updated guidelines on the Indian Child Welfare Act for the first time since 1979. And I did a little happy dance at my desk when I read the portions of the guidelines specifically related to active efforts, because they provide us with a list of 15 examples. And while it's not an all-inclusive list, and it very clearly states that what constitutes active efforts is made on a case-by-case basis, it finally gave us a place to start, and a place to perhaps be able to start looking at perhaps data collection, right? A way to start figuring out if active efforts were actually provided in cases, because it's such an amorphous concept. So the 15 examples that the Bureau of Indian Affairs provides around active efforts in February of 2015 include 1, engaging the Indian child, the Indian child's parents, the Indian child's extended family members, and the Indian child's custodians. So that's very similar to language that already exists within California law, so California's on the right track there. Way to go. Number 2, taking steps necessary to keep siblings together. So again, something that is already contained within California law in terms of maintaining sibling bonds, but had not necessarily been tied to active efforts previously. Number 3, identifying appropriate services and helping the parents to overcome barriers, including actively assisting the parents in obtaining such services. So, in California we have case law around this, that it is not enough to simply refer parents to substance abuse counseling or to go get an assessment for mental health, that there has to be something more to ensure that whatever barriers may exist for a parent in actually receiving those services, that the parent is provided with the necessary support to overcome that barrier. Number 4, identifying, notifying, and inviting representatives of the Indian child's tribe to participate. And we have been interpreting this to mean to participate in court proceedings, to participate in case plan development, things which have been best practice in California for a long time in terms of tribes' participation in case plan development, and legally tribes of course have a right to be able to participate in all court proceedings involving the Indian Child Welfare Act where there is an Indian child of that tribe involved. Number 5, conducting or causing to be conducted a diligent search for the Indian child's extended family members for assistance and possible placement. Number 6, taking into account the Indian child's tribe's prevailing social and cultural conditions and way of life, and requesting the assistance of representatives designated by the Indian child's tribe with substantial knowledge of the prevailing social and cultural standards. Number 7, offering and employing all available and culturally appropriate family preservation strategies. Number 8, completing a comprehensive assessment of the circumstances of the Indian child's family with a focus on safe reunification as the most desirable goal. Number 9, notifying and consulting with extended family members and the Indian child to provide family structure and support for the Indian child, to assure cultural connections, and to serve as placement resources for the Indian child. Number 10, making arrangements to provide family interaction in the most natural setting that can ensure the Indian child's safety during any necessary removal. Number 11, identifying community resources including housing, financial transportation, mental health, substance abuse, and peer support services, and actively assisting the Indian child's parents or extended family in utilizing and accessing those resources. And number 12, monitoring progress and participation in services. Number 13, providing consideration of the alternative ways of addressing the needs of the Indian child's parents and extended family. If services do not exist, or if existing services are not available. Number 14, supporting regular visits and trial home visits of the Indian child during any period of removal consistent with the need to ensure the safety of the child. And finally, number 15, providing post-reunification services and monitoring. So those can all be found within the February 2015 BIA Guidelines, and that's contained there at section A2, what terms do I need to know, active efforts. So hopefully through the guidance that the BIA has provided here, we do start to see more compliance in this area, because this has historically been one of the provisions of ICWA that has been the hardest to seek enforcement of, and the tribes have real frustration around. It has long been CILS's position that you cannot bypass the active efforts requirement. It's contained within the Welfare and Institutions Code section 361.7, which requires that active efforts be made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, and that these services have to be ordered in spite of any bypass considered under Welfare and Institutions Code section 361.5. That the Indian Child Welfare Act is based on a political relationship between the United States government and Indian tribes and is intended to undo some of the government policies that had been in existence that created unwarranted removals of Indian children from their families. And as a result, the federal government has dictated to state courts what needs to happen in those cases, and the active efforts requirement is a part of that overall piece of legislation. So, to my knowledge, every case that we have ever argued on this, we have been successful in. I have had a number of discussions as a part of the overall grant project that allowed these webinars to be produced and trainings to be provided to tribal social workers, that by and large, counties are providing active efforts and not looking at bypass in cases where the Indian Child Welfare Act applies. So that's really good news, and hopefully that is the direction that all counties in California can go to. And with the additional guidance that the Bureau of Indian Affairs provided to us, hopefully we will see active efforts really truly be active efforts going forward. I'm forever optimistic. So in California, county courts are required to make certain considerations and findings before making placement orders. And these are the specific findings that are contained within the California Rules of Court and include a court considering and then finding that active efforts were made and proved unsuccessful. The second is that active efforts were made in a manner consistent with the prevailing social and cultural standards and way of life of the Indian child's tribe. And the third is that all available resources were used, including the extended family, the child's tribe, Indian social services, and Indian caregivers. So all three of these are potential areas that a tribe or parents or even children's attorneys could make arguments around. Active efforts in practice. So what should attorneys and judges expect regarding the requirements of active efforts in these cases? And how would an ICWA case differ from a non-ICWA case? Right? So prior to the matter coming to court, right? So we're right now in the early investigation, pre-removal stage, there's no court case. Active efforts have to be provided to prevent the breakup of the Indian family. And even if at that early stage of the case, must utilize the available resources of the tribe. So the tribe should be contacted. There should be a meeting that is held to ensure that all of the available resources of the tribe are utilized, and the available resources, of course, of the extended family or the larger social structure within the tribe, that if there's an Indian health service available that can provide services, that they are contacted, that those phone calls are made to Indian service providers and the tribe and extended family to bring everybody to the table to really figure out how to ensure that all of those services that are available to the family are provided. Prior to disposition, a court needs to be actually making the finding that active efforts were indeed made to prevent the breakup of the Indian family. And that should be based on documentation that the agency is providing. And really, there should be some discussion with the tribe as well of whether or not the tribe was contacted and whether or not the available resources of the tribe were utilized, both with regard to provision of services, but also with regard to location of extended family members or necessary placements, that really involving the tribe at that very early stage benefits the family and ultimately the best interest of the child. Post disposition, what you're looking at is no longer services to prevent the breakup of the family, but instead reunification services. So that's where we start talking about the development of active efforts case plans. Before we actually move on and talk about qualified expert witnesses, I just want to take a second and continue the conversation about active efforts and case plan development at the dispositional stage of a case, that it is really important that that case plan be negotiated with the tribe, as I said, but also that the services that are identified within the case plan definitely target those issues which brought this family before the court. That for whatever reason there seems to be a disconnect sometimes, and perhaps it's through the use of boilerplate case plans, but it really helps, at least in my experience, to go back and identify those factors that brought the matter before the court and then start really targeting those. But also having a conversation with the tribe around what else needs to be provided to truly target those issues. So for instance, if substance abuse is an issue that brought the matter before the court, certainly you want to be seeking culturally appropriate substance abuse services, but you may also need to be looking at some of the underlying trauma that is affecting that family, and that's where a conversation with the tribe will be very, very beneficial. So that said, let's go ahead and move into qualified expert witnesses. Much like active efforts, actually, the Indian Child Welfare Act itself does not establish precise qualifications for an expert witness. So this is another provision of the Act that really provides room for interpretation. Fortunately, again, in this area, the updated BIA Guidelines provide some clarification, as does state law. The 2015 BIA Guidelines provide some real common sense instruction around qualified expert witness requirements, and provide that a qualified expert witness should have specific knowledge of the Indian tribe's culture and customs, which really does seem like it should not even have to be written down, right? But the reality is it was not that long ago that county social workers were actually acting in the capacity as qualified expert witnesses in a lot of these cases. So this is actually a really big deal, being able to look at the federal guidance and know, okay, so the qualified expert witness should not just be a lay person, cannot be a county social worker, has to be a person that has specific knowledge of the Indian tribe's culture and customs. The 2015 BIA Guidelines also provide us with some beautiful guidance in that they provide a listing of the persons with characteristics presumed to meet the qualified expert witness requirement, but that they also include that bolded and underlined language on the first line of the slide here in descending order. So this list is a hierarchy, and when we move to the next slide and look at state law requirements, you will notice that it is not specifically labeled as a hierarchy, which has caused some real problems for us here in California. So again, this is from the 2015 BIA Guidelines. This is a list of the persons with the characteristics presumed to meet the requirements for a qualified expert witness, and it is a hierarchy. It's in descending order. So federal guidance would tell us that first we should look to a member of the child's tribe recognized by the tribal community as knowledgeable in tribal customs as they pertain to family organization and child rearing practices. So that's a really big deal. So initially we're supposed to be looking to a member of the child's tribe. And then we come down to a member of another tribe that's recognized by the child's tribe as a qualified expert witness. And some of these I've paraphrased so that they all fit on the slide, but certainly we're getting the gist here, and the BI guidelines are very, very accessible online. The third here on the list is a layperson recognized by the child's tribe. Fourth, then, is a professional person having substantial education and experience in the area of his or her specialty who can demonstrate knowledge of the prevailing social and cultural standards and child rearing practices in the child's tribe. So again, really big deal that we start out with a member of the child's tribe, and then we drop down to a member of another tribe, and then a layperson recognized by the child's tribe. This list is really intended to ensure that the child's tribe has a lot of discretion around who this expert witness will be, which is critical because one of the reasons that ICWA has a requirement around qualified expert witness to begin with is so that that person can assist a state court in really understanding the issues through the appropriate cultural lens, right? Because one of the reasons behind the passage of ICWA was an unwarranted removal of Indian children for a lack of cultural understanding, and really at this point it's also trying to undo a lot of the damage, the trauma, the intergenerational trauma that's been done to these communities. And so being able to understand that through the appropriate lens is really, really important. In ensuring that the child's tribe has discretion over who this person is should really help in ensuring that the appropriate lens is actually used. So let's go ahead and take a look at state law with regard to qualified expert witnesses. The introductory sentence here looks very similar to what we saw in the BIA Guidelines, where it says that this is a list of persons most likely to meet the requirements for a qualified expert witness, but you will notice that it does not include the phrase in descending order. It doesn't specifically reference this list as being a hierarchy, which has created a lot of difficulty in California courts. Even though the list certainly reads like a hierarchy and common sense would seem to dictate that it is a hierarchy, that is not the strict interpretation that it has been given. So there is great hope that through the guidance that's been provided by the BIA that this list will start to be interpreted as a hierarchy, and that we will be able to also amend this code section to specifically document that it is that this list is supposed to be read in descending order. But for now, let's go ahead and get started with the list. Number one, similar to the guidelines, supposed to be looking for a member of the Indian child's tribe. In this case, who is recognized by the tribal community as knowledgeable in tribal customs as they pertain to family organization and child rearing practices. Number two is any expert witness having substantial experience in the delivery of child and family services to Indians and extensive knowledge of prevailing social and cultural standards and child rearing practices within the child's tribe. And then number three is a professional person having substantial education and experience in the area of his or her specialty. Now I have to ask how anybody could read this list and not interpret it as a hierarchy. If the intention of ICWA is to assist a state court in having the appropriate lens through which to view the factual scenarios, how would a professional person having substantial education and experience in the area of his or her specialty possibly be able to do that as well as a member of the Indian child's tribe? In any case, this is where we are. We are very hopeful that we will be able to, again, create a situation where there is clarity for all. Certainly that was the intention of the BIA in publishing the 2015 guidelines, and my fingers are crossed. The Welfare and Institutions Code does, though, specifically state that the expert should not be an employee of the agency recommending foster care placement or termination of parental rights. That is huge. Like I said, it used to be that county social workers were very often the qualified expert witnesses in these cases, which was entirely inappropriate. So this is a big bonus here in California. And we also typically suggest that the expert witness not be the tribal social worker in cases where that tribal social worker is also representing the tribe in the state court custody proceeding as essentially a quasi-attorney in the courtroom. That really requires that person to wear too many hats and creates a position of conflict. So as a practice tip of sorts, we highly recommend reminding the court and parties that there are compelling reasons for the court to ensure that an expert witness actually possess the knowledge and experience specific to the Indian child's tribe. Again, really being able to view it through the appropriate cultural lens. And that primarily both state and federal law is premised on the protection of the Indian child's connection to his or her tribal community and culture. Right? That if you're looking at ensuring that children are not being improperly removed from their homes, if you are looking at ensuring that active efforts are being made consistent with tribal and social and cultural standards, there has to be an understanding within the state court systems of what that actually looks like. And a qualified expert witness is supposed to be the person who can assist the court and really other parties, particularly non-Indian attorneys in the courtroom, with that piece of it. So an expert witness with knowledge or experience specific to the Indian child's tribe also allows the court to satisfy the requirement of considering evidence of the prevailing social and cultural standards of the Indian child's tribe, including that tribe's family organization and child rearing practices, which is mandatory in addition to the testimony of a qualified expert witness. That, again, the qualified expert witness can really assist the court in understanding the overall landscape of the case for the court. And that can assist with determinations around appropriate placements, with regard to whether or not active efforts have been appropriate, and of course to the two very specific issues that a qualified expert witness is required to testify to under federal law. Thank you. We really hope that this webinar has been able to provide some additional information on the active efforts and qualified expert witness requirements of the Indian Child Welfare Act. And we encourage you to take a look at some of the other webinars on our website, as well as other published material on our website around the Indian Child Welfare Act. And you are welcome to email me with questions that you might have as well. My email address is there and is on our website. Thanks again. Bye-bye.